Hi friends, I am Krishna Kumar, Assistant Professor at School of Law, Dr. Hari Singh Gaur Vishwavidyalaya, Sagar, Madhya Pradesh. Today in this lecture, we will discuss and have an overview of the Indian Evidence Act 1872. The whole topic is divided into 6 modules. Module 1, Introduction, Module 2, Relevancy of Facts, Interpretation Clause, Module 3, of Relevancy of Facts, Res Gestae, Module 4, of Relevancy of Facts, Statements, Module 5, of Relevancy of Facts, Character, Module 6, Conclusion. Now, we are moving on Module 1, that is Introduction. As you all know that the law of evidence is a system of rules for ascertaining the controverted questions of facts in judicial inquiries. It is basically a procedural or adjective law having overtones of substantive law. For example, the law of estoppels. The Indian Evidence Act 1872 was passed with the main object of preventing indiscipline in the admission of evidence by enacting a uniform rule of practice. Indian Evidence Act 1872 applies to all judicial proceedings in or before any court, including court martial, except under Army Act, the Naval Discipline Act, the Indian Navy Discipline Act 1934, the Air Force Act. It may also be noted that Evidence Act does not apply on affidavits presented to any officer or any court, nor it applies to any proceedings before any arbitrator, as is provided by section 1 of the Act. The Indian Evidence Act 1872 is divided into 3 parts. First, Relevancy of Facts, Chapter 1 and 2 containing sections 1 to 55. Second, on Proof, Chapter 3 to Chapter 6 containing sections 56 to 100. Third, Production and Effect of Evidence, Chapter 7 to Chapter 11 containing sections 101 to 167. Here, under part 1 of the topic, we are discussing the first part, that is Relevancy of Facts containing sections 1 to 55 in the further modules of the topic. Module 2 of Relevancy of Facts, Interpretation Clause. The Act under section 3 defines certain terms which are as follows. Fact means anything, state of things or relation of things capable of being perceived by senses, see, touch, taste, hear and smell. It also includes any mental condition of which any person is conscious. Examples of fact: A. The blood of the victim on the spot or over the knife is a fact, relation with the things, that is knife. B. Presence of victim and accused at the spot immediately before occurrence is also fact, state of things. Facts in issue means and includes: number 1, any fact from which either by itself or in connection with other facts the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. Second, any fact asserted or denied in answer to an issue of fact recorded under the Civil Procedure Code. A fact in issue is called the principal fact or fact probandum. Thus, facts in issue means facts which can establish right, duty, liabilities or obligations. Under civil law, a dispute relating to possession of house, ownership would be fact in issue, since once the ownership is decided, who should have possession can easily be decided just by the application of law. Under criminal law, ingredients of an offence are facts in issue. Evidence. The word evidence means and includes all statements which the court permits or requires to be made before it by the witnesses in relation to matters of fact under inquiry. Second, all documents produced for the inspection of the court. Thus, the term evidence includes both oral as well as documentary evidence. Module 3 of relevancy of facts, res gestae. Relevant facts. One fact is said to be relevant to another when one is connected with the other in any of the ways referred to in the provisions as described in sections 6 to 55 of Indian Evidence Act 1872. Principle of res gestae. Facts forming part of transaction are described by English and American writers as being res gestae, that is, things done in the course of transaction. However, in India, such facts are codified from section 6 to section 11 of Indian Evidence Act 1872. According to section 6, all facts which are connected with the facts in issue due to proximity of time, proximity of place, continuity of action, continuity of purposes, whether happen at the same time and place or different time and different place, are said to be part of the same transaction. While according to section 7, the facts which are the occasion, cause or effect, immediate or otherwise, of facts in issue constitute the state of things under which they happened and afforded an opportunity for their occurrence or transaction are relevant. For example, A is accused of murder of B by beating him. Whatever was said or done by A or B or by the bystanders at the beating or so shortly before or after is as to form part of the transaction is a relevant fact. According to section 8, any fact is relevant which constitutes or shows a motive, say example, previous fighting, property dispute, love affair, family dispute, business, rivalry, etc. or preparation, say example, just before the murder accused purchased a gun or bullets or took training for shooting, etc. for any fact in issue are relevant fact. According to section 9, any fact which is necessary to explain or introduce a fact in issue or any relevant fact which support or rebut any inference suggested by a fact in issue or relevant fact which establish the identity of anything or person, which fix time or place at which any fact in issue or relevant fact happened, and which show the relation of parties are relevant. When A is accused of a crime, he absconded soon after the commission of the crime is relevant under section 8 as a conduct subsequent to and affected by facts in issue. However, the fact that at the time when he left home he had sudden and urgent business is relevant as tending to explain the fact that he left home suddenly. The details of the business on which he left are not relevant except as are necessary to show that the business was sudden and urgent. When A is accused of theft, the fact that he was seen giving the stolen property to B, who is seen to give it to A's wife. B says as he delivers it, A says that you are to hide this. B's statement is relevant as explanatory of the fact which is a part of the transaction. The fact that some witnesses identified the accused during test identification period TIP is relevant to establish the identity under this section. Section 10 is most often used section in cases relating to conspiracy. Section 10 has been deliberately enacted in order to make acts and statements of a co-conspirator admissible against the whole body of conspirators because of the nature of crime. According to section 11, facts not otherwise relevant are relevant. Number 1, if they are inconsistent with any fact in issue or relevant fact. Second, if by themselves or in connection with other facts they make the existence or non-existence of any fact in issue or relevant fact highly probable or improbable. The question is whether A committed a crime at Calcutta on a certain day. The fact that on that day he was at Lahore is relevant. Other relevant facts, section 12 to 16. Section 12 provides facts enabling court to determine the amount of damages or compensation are relevant. For example, at given time, income of victim's family, medical expenditure after accident, etc., while Section 13 provides that facts necessary to establish a right or custom in question are relevant. For example, A demands easement right through property of B. The fact that he has enjoyed it for last many years are relevant since it prove the easement. According to Section 14, facts showing existence of a state of mind or of body or bodily feelings are relevant. For example, A is tried for a crime. The fact that he said something indicating an intention to commit that particular crime is relevant. According to Section 15, in cases of ascertainment of act as accidental or intentional, the fact that such act formed part of a series of similar occurrences in each of which the person doing the act was concerned is relevant. For example, A is accused of burning down his house in order to obtain money for which it is insured. The fact that A lived in several houses successively, in each of which a fire occurred, and A received payment from a different insurer are relevant as tending to show that the fires were not accidental. According to Section 16, existence of course of business are relevant when there is a question as to whether a particular act was done in which, according to the given course of business, the said act naturally would have been done. Module 4 of Relevancy of Facts Statements. In this module, we will discuss about the relevancy of facts regarding statements. Admission. An admission is a statement, oral or documentary, which suggests any inference as to any fact in issue or relevant fact, and which is made by a party or any person connected with it. Admissions are not conclusive proof of the matters admitted, but they may operate as estoppel under the provisions hereinafter contained. Admissions are those statements made by the parties which are against their own interest. For example, when the question between A and B is whether a certain deed is or is not forged, and A affirms that it is genuine, B that it is forged. Here, A may prove a statement by B that deed is genuine, and B may prove a statement by A that deed is forged, but A cannot prove a statement by himself that the deed is genuine, nor can B prove a statement by himself that the deed is forged. Under Section 18, 19 and 20, the statements of following persons are relevant. A. Parties to the suit or proceeding. B. An agent authorized by such party. C. Party suing or sued in a representative character, making admissions while holding such character. Example, trustees, executors, etc. D. A person who has a proprietary or pecuniary interest in the subject matter of the suit during the continuance of such interest. E. A person from whom the parties to the suit have derived their interest in the subject matter of the suit during the continuance of such interest, that is, predecessors in title. Section 18. F. A person whose position or liability it is necessary to prove in suit, if such statement would be relevant in a suit brought by or against himself. Section 19. G. A person to whom a party to the suit has referred for information in reference to a matter in dispute. Section 20. Admission can be made both in civil as well as in criminal proceedings, and can be proved against the persons who make them or his representative in interest. Confession. confession is an admission in criminal matter, where accused admits guilt in its absolute terms, leaving prosecution to prove nothing. In other words, confession of guilt in its entirety may be termed as confession. According to section 24, no confession given by an accused person would be relevant if it were given in a criminal proceeding and it was given under any inducement, threat or promise with reference to the charge against him, and such inducement, threat or promise was given by a person in authority and sufficient in the opinion of the court to give the accused person grounds which would appear to him reasonable. No confession made to a police officer shall be proved as against a person accused of any offence, section 25, and even under police custody unless it is made in immediate presence of a magistrate shall be proved as against such person, section 26. Only coercive confessions are made inadmissible. However, if the accused want to confess voluntarily, then Code of Criminal Procedure prescribes such procedure in section 164 clause 3, and a magistrate, when satisfied that accused is making confession voluntarily, may record the same, and that can be used as substantial piece of evidence against the accused. If the confession is made through this process, it is called a judicial confession. Any confession made otherwise to any person such as friend, stranger, etc. is called as extrajudicial confession. An extrajudicial confession is legal and valid. Exceptions to the rule of confession. Section 27 of the Act provides that when any fact is deposed to as discovered in consequence of information received from a person accused of any offence in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates distinctly to the fact thereby discovered, may be proved. For example, if accused says that I killed B and I can show you the place where I have buried the knife. In this statement, police, if discover the knife, then the fact that it was discovered at the instance of accused may be proved. Section 28 provides that if such a confession as is referred to in section 24 is made after the impression caused by any inducement, threat or promise has, in the opinion of the court, been fully removed, it is relevant. Section 29 provides that confession otherwise relevant not to become irrelevant because of promise of secrecy, etc. For example, B asked A, an accused of murder, to make the confession to him, and he, B, promised that he will not disclose it to anyone. Since it is an extrajudicial confession which is admissible, it will not be held inadmissible only because there was a promise of its secrecy. Section 30 provides that when a confession is given by one accused and the same was proved, it can be used against the co-accused if he is tried together in the same case during the joint trial. Dying declaration. As a rule of evidence, no statement given by any person can be used as evidence until he comes to the court and testified on oath as to the veracity of his statement. Section 32 provides statements, written or verbal, made by a person who is dead or who cannot be found, or who has become incapable of giving evidence, or whose attendance cannot be procured without an amount of delay or expense which, under the circumstances of the case, appears to the court unreasonable, are themselves relevant facts in the following cases. 1. When it relates to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of the person's death comes into question. 2. When the statement was made by such person in the ordinary course of business. Number 3. When the statement is against the pecuniary or proprietary interest of the person making it. 4th. When the statement gives the opinion of any such person as to the existence of any public right or custom or matter of public or general interest of the existence of which, if it existed, he would have been likely to be aware, and when such a statement was made before any controversy as to such right, custom or matter had arisen. 5th. When the statement relates to the existence of any relationship by blood, marriage or adoption between persons as to whose relationship by blood, marriage or adoption the person making the statement had special means of knowledge, and when the statement was made before the question in dispute was raised. 6. When the statement relates to the existence of any relationship by blood, marriage or adoption between persons deceased and is made in any will or deed relating to the affairs of the family to which any such deceased person belonged, or in any family pedigree or upon any tombstone, family portrait or other thing which such statements are usually made, and when such a statement was made before the question in dispute was raised. 7th. When the statement is contained in any deed, will or other document which relates to any such transaction as is mentioned in section 13 clause A 8, when the statement was made by a number of persons and expressed feelings or impressions on their part relevant to the matter in question. Public entries, documents and judgment of the court. Section 35 provides that entry in public record or an electronic record made in performance of official duty is relevant. Section 36 provides that statements of facts in issue or relevant facts made in published maps or charts generally offered for public sale, or in maps or plans made under the authority of the central government or any state government as to matters usually represented or stated in such maps, charts or plans are themselves facts. According to section 37, when the court has to form an opinion as to law of any country, any statement of such law contained in a book purporting to be printed or published under the authority of the government of such country, and to contain any such law, any report of a ruling of the courts of such country contained in a book purporting to be a report of such rulings is relevant. Section 40, 41 and 42 provides for the relevancy of judgments, orders or decrees of a competent court under various circumstances, while section 43 provides for the relevancy of judgments etc. other than those mentioned in section 40 to 42. Section 45 provides for the relevancy of the opinions of the third persons, if they are the experts or persons having special knowledge in the respective field, and court will have to form an opinion upon a point of foreign law or of science, or as to identity of handwriting, finger impression etc. According to section 46, which provides for facts not otherwise relevant are relevant if they support or are inconsistent with the opinion of experts when such opinions are relevant. According to section 47, when the court has to form an opinion as to the person by whom document was written or signed, the opinion of any person acquainted with the handwriting of the person by whom it is supposed to be written or signed, that it was or was not written or signed by that person, is a relevant fact. According to section 47A, when the court has to form an opinion as to digital signature of any person, the opinion of the certifying authority which has issued the digital signature is a relevant fact. Under section 48 and 49, opinion may take to decide questions relating to right or custom or usages, etc. Section 50 provides that when the court has to form an opinion as to the relationship of one person to another, the opinion expressed by the conduct as to the existence of such relationship or any person who, as a member of the family or otherwise, has special means of the knowledge on the subject is a relevant fact. Module 5 of Relevancy of Facts, Character. Section 52 provides that in civil matters, character of a person is irrelevant unless be excluded from evidence only, because it is incidentally exposes or throws light on party's character, while in criminal matter, character of the accused is not relevant. However, if party wants to suggest evidence of good character under section 53 to take some relief, then prosecution may adduce evidence of bad character as well as under section 54. Objective of the topic. The objective of the topic is to present an overview of the Indian Evidence Act 1872 to the students in a simple language easy to understand. The topic aims to present to the students some of the definitions given under the Act as well as the facts relevant and which can be admissible as evidence in the courts of law. Conclusion. The relevancy of the facts is to be judged in the light of the provisions of the Indian Evidence Act 1872 as is covered in the topic. The relevancy is to be judged in accordance with section 5 to 55 as is discussed in the topic. Otherwise, the facts are irrelevant and the court will not take them into its consideration. With all these information, here we come to the end of today's lecture. Do keep in mind what we have discussed today. It is time for you all to do some self-study. This is Mr. Krishna Kumar signing off. If you want to learn more and enhance your knowledge, you may log on to our website for MCQs, quizzes, LORs on www.cec.nic.in. Till then, goodbye.